The State Board of Elections meeting set for June 25th, 2026. Um, I do declare a quorum is present. Are there any additions to the agenda? Uh,
Have
Member Butler.
new business and old business.
Okay. What you're adding to new and old business?
I just want to speak at new business and speak.
Okay, gotcha.
Thanks.
No problem.
Okay.
All right. With that, we are moving on to approval of the minutes for open meetings, May 29th, 2026, and June 9th, 2026. Any discussion? Any edits? Any additions? Member Butler?
One edit on page 9 of the minutes. Yeah, one method on page 9 of the minutes, the 8th paragraph, it should say closed and not close.
Is that for May 29th or June 9th? I'm sorry.
I don't, it's the one that had nine or 10 pages. I didn't write down which one it was. I just wrote down what it needed to be fixed. Sorry, I didn't send it, but I didn't get to that till late last night.
Right. Well, we definitely need to know which one.
Would it be May
we're on.
29th? June,
Okay.
May 29th, June
Yeah.
6th, June 9th was a abbreviated meeting, so
Right.
Yeah.
I would assume that would be the one.
May 29th.
Thank you, member Jackson Stanley. I was looking it up as we was, but I was thinking, yes, it is correct.
With
When
that, Mr. Chair, I'm sorry,
Yes.
Diane, there was something else?
Yeah, there were some other corrections and then we got the second set, but this needed to be corrected also.
All right. Is there a motion to, okay, I'm sorry, Member Jackson Stanley?
Yes, sir. I was going to make the motion that we approve the minutes of May 29th and June 9th as corrected.
So moved. Is there a second? Probably seconded by Member Butler. All those in favor, please indicate by raising your hand. All right, thank you. Have you all received the closed meeting minutes? Reviewed? Reviewed them?
Yes.
Are there any questions, concerns, discussions, amendments, edits? Hearing none, the chair is open to a motion to accept the closed meeting minutes. So moved by the vice chair. Is there a second? Properly seconded by Member Butler. All those in favor, please indicate by raising your hand. So moved. Minutes accepted unanimously. Thank you so very much. And that was for the closed meeting on May 29th, 2026. On to State Administrator's Report.
Yes, well, thank you, Mr. Chair. I first off just want to, before I go into the State Administrator's Report, I just wanted to thank all the election judges out there that helped us conduct the 2026 gubernatorial primary election. Without their support and, basically being a volunteer, they get paid, but not a lot, for the work that they do, the tireless hours, especially on primary day. I can't thank them enough for their civic duties to help make primary election go forth. And so they've been trained, and we want them to come back for the general election. So we needed the almost 26,000 individuals to come out, and I just thank you, and we still need them as they are doing the mail-in ballot canvass and the provisional ballot canvass post-election. Everyone forgets about that, but that's started today. So I just wanted to thank them and their time and efforts for everything that they do. The primary election and early voting. There was early voting statistics have proven that more people voted in this election than in 22 or in 24's primary election. We have started the mail-in ballot canvass across the state for the post-election canvass, and we have over 218,000 mail-in ballots that were received. We expect some more to come in because Maryland is a postmark state. So all they had to do was be postmarked on or before Election Day. So, but they have to be received within 10 days of Election Day. So we're expecting a few more coming through the mail. But we're counting every ballot and ensuring everyone's voice is heard. So I just wanted to say that. And now on to the state administrator's report. I have submitted this to you ahead of time, but I just wanted to kind of hit a couple of highlights here. I attended an event at the Carter Center on June 8th with the Empowering Secure Elections Lab. And they were there to promote our new app, Go Vote MD. It's been great working with with those teams there with the app, and we always look forward to continuing to improve that app and make it a better voting for the voters experience with information. So we're excited that we got the groundwork done. It was successfully launched for the primary election, and we're looking to always make improvements now that we have it. And we encourage everyone to download that app for information about the electoral process in Maryland. The Maryland Department of Disabilities reviewed and tested the proposed voting system on June 17th, and in particular, the ballot marking device. We are as I mentioned before, in the Canvas. And now for candidacy and campaign finance, we had 20 new committees established since, between May 21st and June 16th. The biggest deadline for candidacy right now is the declaration of intent for petition and non-principal political party candidates, and that is July 6th, so that's rapidly approaching. That means that they have to submit a declaration of intent. They don't have to submit their petitions or their nomination papers until until in August. So this is their first deadline, but if they don't file the declaration of intent, then they can't do both in August. So this is an important deadline here. We had the pre-primary 2 report. It's great to see over 90% filed on time, and that late filers are being assessed daily late fees. But that was the last report right before the primary election, and I always like to see that we have a high success compliance rate there. The next report due is for Central Committee candidates only, and that is due on July 14th. So it's important that they file those reports with us. If they fail to file or have outstanding fees, they cannot receive their commissions for office to take their seat on the Central Committee. So they need to make sure that they file this July 14th report with it. The business disclosure report, which was due on June 1st. Again, it was great to see a high compliance rate of over 96% filing on time. We have, public financing. There was a lot of activity throughout the counties. It was, a lot of money was dispersed, and with Montgomery pretty much leading the charge on the amount of money dispersed. But Howard was almost $1 million there. So it was, again, very successful programs at the county level, which we help support. We have listed all our enforcement actions from the month of May. The team has been very busy about that. In communications, social media, and we've done an extensive voter outreach program. And we had a special primary landing page developed again, to make sure that the voting experience and clarity of messaging was there. We saw that I think that the voters had a very easy time understanding where to go, how to vote, and all important deadlines there. And we definitely, Lexi kept me very, very busy throughout the time period there. In election management and compliance, we had the correctional facility voting. We always take that and make sure that we're, applying those packets there to make sure that those individuals have the chance to cast their ballot. And we supplied over 10,000 voting packets throughout the correctional facilities throughout the state. And we had a couple of the contractual staffing for election because, as you know, we, ramp up so much for the primary election. And so the surge staffing support contract is coming to an end for the primary election. And so, we'll, shrink that now and then gear that back up later on for the general election. Uh, all the voting equipment was transported and delivered throughout the state, successfully. There was no issues there. And now everything is just being collected. And, Russell and his team is just doing a fantastic job there with logistics. And it's just, very good. So it's fantastic. We are also getting a lot of Public Information Act requests, which we have, just documented for you and, just to let you know how many we are receiving and, that it's always been increasing as well. In the information systems and technology aspects here, we are, working on the 2028 electronic poll book solution there. We had to, we're always working with our new vendor, 10X. So, we're still on track there. It was great to see everyone helping multitask during this important time period of the 2026 election, but we're expect to be ready for a statewide test in early 27. So that's been fantastic, and we're on schedule for the 28 election for that. Mail-in voting, we did our final poll with the vendor on June 10th, and then we switched it over to the local boards of elections, and everyone was able to get their ballots. It was big efforts there, but we did a fantastic job. And one of the things was about customer service and customer service support here. We made it a priority because of what happened with the mail. And, and we wanted to make sure that not only did we have all the voter outreach efforts there with text messages, emails, and postcards, but we also knew that the voters might be a little bit confused as well. And we, had staff from all the various departments assist with our customer service group and answering voting emails and taking calls that were forwarded from the call center. And, we had received over 17,600 calls. Zoho tickets, by the way, are emails that we received. That's just our ticketing service system. That's what it's called. And you saw that we had over 7,700 emails that were closed, and all those were answered or calls back within 24 hours of an email or a call. So, we engaged and made sure that, nothing was, going to impact the voting experience or delay voters from understanding what, exercising their constitutional right. So, it was just an amazing effort from our team. And, I cannot say enough about how many people pitched in just to make sure that everyone, and I mean everyone, was able to vote. And, you can see that, and our team and the efforts that they did are just fantastic. So I appreciate everything that they are doing. Right now we're also making sure that if there's any issues with mail-in ballots, that they have the ability to cure. We're doing the curing by text again. And so far, 9 have been completed by text method to cure. In HR and personnel management, right now we're just conducting interviews for the director of candidacy and campaign finance. But some of the big news is at the locals, where Lisa Stanley is now the acting deputy director over in Baltimore City. She's been with the agency up there since 2011. It's a fantastic choice. And I was just up there for the canvas today, and it was, Cliff and the team have been just doing a fantastic job in Baltimore City. But they do need a new warehouse. So I did say that I was going to plug that at this meeting here, that they do need a new warehouse, and I will make sure I'll work with the Scott administration and the elected officials up there and the comptroller's office to help them get a new state-of-the-art warehouse. Veronica Fox is now the acting deputy director in Wycomico County, and she has been with the agency for a few months as well. So we have a whole bunch of active procurements here. The biggest one here is that the contract for the new voting systems is slated for the July 1st BPW meeting. And, we're of course finalizing all the materials for the Office of State Procurement and any questions that the BPW members have. And one of the other things too is I just wanted to keep you all informed about the voter registration and election administration modernization one, which is basically our statewide voter registration database and includes other modules which are very important to election administration. And that is currently with DeWitt for review. Once DeWitt approves, then it'll be routed over to the Office of State Procurement for their review and the approval to publish. So we are trying to make sure that that gets out so that we have a lot of time for vendors to respond back to it and make sure that they have given us complete, timelines and, I would say products for us to review. So that's our next big contract that has to go out, and known as VREAM in our agency here, but that's the next big one. And so, be on the lookout for that one if anybody else is watching or listening to this. We had a recent award about our election judge texting solution contract here. This was a system to allow election judges who are working in the field to receive and report emergency instructions, information, threats, or concerning about their polling places, so that we have this ability to make sure that when they were out there that we were in constant communication with them. So that was a nice solution to provide the judges so that they can just text us if there's issues or any emergency issues that had to do with their polling locations. So that's been great. In voter registration and audits, we have been, of course, busy. The close of advanced voter registration was June 2nd. That was also the deadline for registered voters to change their party affiliation. And, we have a closed primary election. So that was a major change or major deadline for individuals who were registered to vote as unaffiliated or with the non-principal political parties. If they wanted to participate in a Democrat or Republican primary, they had to be a member of that. Otherwise, they would be voting the nonpartisan school board elections if they were available in that county there. And with that, there was just some more statistics for everyone to see. We have over 4.3 million registered voters, and we did not exercise any delegated duty since the last report there. But with that, I submit the state administrator's report to the board.
Thank you, State Administrator. Any questions for the State Administrator from the membership? Yes, Member Butler. Member Butler, I think you're okay.
Yeah, I fixed it. Yeah. I have two questions for you. So, and this is a complicated one. It ballots to cure, we have this 10-day issue. So are we going to cure the ballots that are coming in on the very last day? I think we're doing them in July when we're, the last canvas day, the ones that came in from the mess up with Taylor. Are we allowing the citizens that their ballot didn't count? Are we allowing them any kind of way to vote?
So they received the replacement ballot.
Okay, so we don't have any that just the first one came in?
So, right. So
no,
the
yeah.
cure was for those individuals to vote the replacement ballot.
Yeah, okay. All right, and then I have one more question, and I do want to agree with you and thank all the judges, because without the judges, this doesn't fly. And thank you for working, and please continue to work. And if you're watching this and have never done it before, it's kind of fun. It's interesting. It's a long day, but it's well worth doing. And then question for you, Jared, what happened to at the state level with the backup batteries? So we had an issue where the system wasn't updating in real time, so like the other counties weren't updating, which can be a big problem if if somebody could vote here and then run over and vote somewhere else if it's not updating. I know that in Howard County, we were very careful with our equipment to check all the equipment beforehand. So I think something needs to be done there because obviously the batteries weren't checked. And then I think you got some help with the Howard County director in order to fix that system. But that's an extremely important system because if that is not backing up minute to minute, then that allows anybody to go vote in more than one place. So what are we going to do about that?
We have a generator outside, and we made sure that if the power is ever lost in the state, that we have the backup generator on standby.
Yeah.
And if you want to come over to the headquarters one day, you get to see the big generator that is now being outside of our office to make sure that the power, if the power can go down in Annapolis, hopefully not, that it will, we have this big generator that can last, I believe, 3 days.
Yeah, okay, because I know we'd had tabletops on how to deal with all
Yes.
that stuff. Yeah, I was gonna come over, but by the
Yeah.
time I flew in, it was raining so hard, I just gave up, so. all right.
Exactly. Yes. Right. I kept on saying the best indoor activity was to go vote. So you can't,
Yeah, okay. But that we have to really pay attention to that because that is such an important part of the system working. All right, thank you.
Thank you. Member, Vice Chair Shallot.
Thank you, Chair. Jared, I echo what you and Diane said. Thank you to all the workers, judges. That's the definition of democracy. Whenever I go see them canvassing and working the polls, it's just democracy in action, and God bless them for what they do. I've raised this before, and I don't know if this is the right time to raise it. You talked about the Taylor issue with the mail-in ballots and everything. I've gotten, and I'm sure you've gotten 10 times more inquiries than I have about what happened. What happened? Whose fault is it? What are we going to do about it? How do we prevent it again? Lots of inquiries. So my question is, it's basically the elephant in the room about the mail-in ballot issue. Are we going to have, because I think transparency is the key word, are we going to have a comprehensive review? I would recommend an outside review, independent, of what happened here and whose fault was it? Obviously, people are questioning what happened. And so my question to you, Jared, is, are we going to have a comprehensive, independent investigation? Well, inquiry. I don't want to say investigation because it kind of connotes that's something venal was done. Are we going to have an inquiry, review, whatever you want to call it, independent of what happened here? I mean, I'm watching C-SPAN. I'm a news junkie, and they were discussing it at a congressional hearing about Maryland and what happened. The president has chimed in on what happened in Maryland. So, unfortunately, we've become a national story. So I just ask and urge you to consider an independent investigation, A to Z, so we all know, the public knows what happened and how we can prevent it again. I just
So
would urge you to
answer
consider
your
that.
question, I'll bring, I believe that we'll make sure that Taylor comes in. We're going to do our lessons learned and we're going to present that, but we'll bring Taylor in front of you, the board here for the July meeting. So you get to ask your questions. You're independent of me. That is your role. So that you represent and you represent your stakeholders, the political parties, and you have the ability then to ask those direct questions to Taylor. I think that's the process here. I like if there is if the General Assembly so wishes to do the same, I'm happy to always go downtown to answer any and all questions. But right, so we'll bring in Taylor for you to ask those questions, Member Shallot.
No, I appreciate that. I don't raise this as a criticism because we don't know what happened, but wouldn't it be better and more transparent not to investigate, forget that word, not to inquire, review ourselves? Wouldn't it be better to have an independent agency or group, whatever you want to call it, to look at what happened from outside as opposed to us reviewing it ourselves in terms of, how the public.
I think there's a difference between, and I'm sorry, I'll let Member Bryant answer or raise a question there, but we're separate, right? Like I run the day-to-day operations. You get to oversee my day-to-day operations, and this is probably one of your parts of overseeing the administration of the electoral process, and you're independent of me, and so you can ask those questions. The General Assembly is independent of both of us. They can ask those questions. I think that those are the appropriate avenues here. So I don't necessarily know of any other type of inquiries that would be able to exist. So that's why I think we have this. But
I would just ask you to consider, what I'm asking you to do. I appreciate that.
Thank
Thank
you, Vice Chair. Member Bryant.
Thank you, Mr. Chairman. As it relates to the vice chair's discussion point and the administrator's insights related to it, Mr. Vice Chairman, I'm very comfortable. Well, the bottom line on what I was going to suggest or my response is, I think that it's not either or, it could be and both. I'm not quite there yet on the concept of an independent investigation, but having, if it's the chair's will and the body's will, having this entity, this vendor appear before the state board next month and address any considerations, concerns, questions, or anything in between that the board might have, I think it's a good thing because that gets them right in front of the Maryland public and the American public, quite frankly, in this public setting. But it also doesn't foreclose anything that might come up thereafter. We could have that so-called follow-up independent inquiry. We could submit follow-up questions in writing. We can submit questions ahead of time in writing ahead of the July event. So that comes back around to the concept of it may not be either or, it could be both and, but in the moment, I feel very good and comfortable about getting them in front of us sooner rather than later. And that would be the July board meeting, if it's the will of the chair and the body.
If I could just respond, Mr. Chair?
I believe not. I don't have a problem with that, but I believe I saw Member Jackson Stanley's
I'm sorry.
hand or Member Butler prior to.
Jim
Member,
picked ahead of me.
Member Butler. Okay.
After you.
Go ahead, Jim.
No,
Are you gonna-
I'm seating either you, Member Butler, or Jackson Stanley. I saw both of you prior to the vice chair.
Thank you, Mr. Chair. My comment is similar to Member Bryant. I think bringing you gave the name, Mr. Jared, bringing them to
Yeah,
us
right, yeah.
thank you, bringing that body to us to at least let us be the first line of inquiry. I like the word inquiry versus investigation, Mr. Vice Chair. It is important that we are transparent. I agree with that, but it also gives us an opportunity not to have an independent entity get ahead of us. We should be comfortable because we are the ones that the citizens will have to approach. I've had very few comments here on the shore. The shore was not as impacted as you all, but we are also very concerned that we don't want our rights overstepped. We need to be on top of this before we have someone from the outside ask questions. I like the idea of questions ahead of schedule, ahead of time, and it would be important for me to just have them tell me what happened. When I got the call initially, and just for one more minute, my first question to Jared was, so what did they do wrong and who's going to pay for all of this postage? I'm one of those that want to believe that the taxpayers have a right to know who's paying for these mistakes. Mr. Chair, I yield my time to Member Butler only because you saw my hand go up, but I didn't want to jump ahead of her. But thank you for giving me a little bit of time to agree with Member Bryant that bringing them to our body in July, I think is the appropriate method for the reasons I've given the citizens an opportunity to hear us ask questions about not so much fault, Mr. Vice Chair, but how did this oversight, how did this mistake happen? I don't want to throw blame until I have more insight from what they said to us. Thank you, Mr. Chair.
Thank you, Member Jackson Stanley. Member Butler.
Yes, I agree with Eric. I think that the either and, I think having questions beforehand is one thing. I think also when we talk with Taylor, I think there will probably be questions that we're going to need to think about afterwards also. So if we have the opportunity and if we feel the need afterwards to go to an independent agency, then that would be like Eric said, or Member Bryant said, the either or. So I think bringing it to us first and allowing us to think about it first and ask questions, and then getting the questions and getting the answers, and then making a decision of what we feel we need to do in order to protect the citizens of the state of Maryland. So I think that was a good idea, and I like Eric's or Mr. Bryant's answer. That gives us the opportunity to bring somebody back in if we listen to the answers and are unhappy, and then we feel like we need something else, then I think then we can make that decision at that time. But it is helpful. We have to address this because it has been a very big issue out at this end of the county. I've probably put 50, 60 hours in just in the last few weeks, just on all of this stuff. So thank you.
Thank you, Member Butler. Vice Chair.
Thank you, Chair. My suggestion is not putting blame on anybody. I just think the public would be more satisfied, be more transparent if we didn't inquire, investigate, whatever you want to call it, ourselves. Mr. Chair, what if we screwed up? What if an independent inquiry showed that we screwed up, the board? And that's a possibility. That's why some independent eyeballs, I think, I think it's a better way to go in terms of the public having confidence in us. The governor appoints us to oversee elections, but what if we screwed up? Are we going to find that we screwed up? I think independent is the way to go. Not that it may happen, but I just think it's a more prudent way to go to have somebody look at what we did, and I just think it's better for the public.
Well, Vice Chair, I don't believe your members are in disagreement with you. I believe your members are saying to you that they would like to have a first brush with regards to inquiry or inquiring about the situation with Taylor, the vendor. So I am inclined to agree with each of you and the recommendation from the state administrator to have Taylor come before us and for us to inquire or solicit or provide inquiry or questions from the public that reach out to us directly to Taylor. I think we can be that go-between to establish the public trust and in our role. I do not mean or want to implicate anyone on this board as being at fault in any way. Even with regards to the situation, mistakes happen, but I am not at liberty to put forth any statement of blame. Thank you. So, with that being said, is there any other questions of the state administrator due to the state administrator's report? All right, hearing none. Member Bryant, yes.
Thank you, Mr. Chairman. I'd like to take a brief moment to acknowledge Tuesday's gubernatorial primary election. I just got a few notes on it. I think we got to say that the election was by and large conducted calmly and professionally. Of course, there were some spirited moments amongst the campaigns at the polls, and as is often the case, understandable anxiety from some campaigns that wanted results sooner on election night. Even still, we got to and through election day in relatively good stead. For me personally, for the better part of 35 years, I've been involved in campaigns in one sense or the next. But as the newest member of this board, this experience has been different. For the first time, the responsibility is not to help any particular campaign succeed, but to help ensure that the electoral process itself succeeds for everyone. So it's given me a greater appreciation for the tremendous responsibility entrusted to this board, as you just described, Mr. Chairman, and as the Vice Chair outlined. So I want to personally thank each of the members, each of you. I'd like to thank Administrator Demarinis and the dedicated women and men of the State Board of Elections, our local boards with whom we share this responsibility, election directors, judges, poll workers, and the countless staff and volunteers whose professionalism make the elections possible. In a different sense, but still wholeheartedly, I'd like to thank the candidates who offered themselves up for public service and the voters who exercised their fundamental right to participate in the democracy. We know there's significant work that remains in the days ahead, including the canvas that has been discussed and addressing the vendor-related issue with mail-in ballots with care, transparency, and the diligence that the public expect from us. But I'm confident that we will continue to do what's been entrusted, which is to get it right to all. So let's keep working and continue earning the confidence that Maryland has placed into all of us. So those are my quick thoughts that I wanted to get on the record. In no small order, the thanks extended to you and the agency and the greater public. Thank you, Mr. Chairman.
Thank you, Member Bryant. Are there any other solicitations? All right, hearing none. Thank you very much, State Administrator. Now moving on to our Attorney General. The report by Assistant Attorney General Dan Corbin. Thank you.
Good afternoon, members of the board. Forgive me, I'm just turning up my volume a little bit so I can hear a little better. Can you hear me?
Yes.
Yes.
Okay, great. I'm actually excited to report that the Assistant Attorney General's report is out of date, that the document you have has a number of updates from the past 30 hours that are all pretty good for the board and its litigation stance. I'll start with the first case, the first two cases, actually. The first case on the list, California v. Trump, the case ending in 10810. So the first California v. Trump. This was the suit that Maryland joined with 18 other states, seeking to enjoin the president's executive order from March of 2025 having to do with documentary proof of citizenship. On Tuesday afternoon, I believe it was, today's Thursday, on Tuesday afternoon, summary judgment was granted in favor of the plaintiff states. In other words, we won. Maryland and the 19 other states were granted summary judgment, and the federal district court enjoined the challenged provisions in the executive order permanently. They are unenforceable in Maryland, and obviously the other states that joined us. And so that suit was a success. It has happened pretty recently. No indication yet if the federal government is going to appeal the case to the First Circuit. On the second case on the list, California v. Trump ending in 11581. This was a lawsuit from April of this year, seeking to, by 24 states, including Maryland, seeking to enjoin provisions in a second executive order that directed the United States Postal Service and Department of Homeland Security to create lists for reference and for directing mail-in ballots from states. Happy to report that this morning, summary judgment was granted to the states, to the plaintiff states. And again, we won. And so the federal district court has permanently enjoined the challenged portions of the executive order, and they are unenforceable in Maryland and in 23 other states. We will therefore be able to conduct our general election without that executive order moving forward. In terms of the next case is Bryson v. Moore. That has no update. That is actually, I've realized, is set for a December 2026 argument month. That does not necessarily mean the case is going to have an oral argument in December. That is seemingly is just when the court is going to accept the case and all the briefing. And that'll be the time, the clock, the starting point for the clock for when we might get a decision. For now, however, all filings on behalf of the appellees, of which Chairman Summers and State Administrator Demarinis are two, have been filed, and our work is complete in that case. United States v. Demarinis, number 4, is more good news. We had a hearing on, this is the voter registration case, the lawsuit brought by the Department of Justice against the state administrator to demand disclosure of an unredacted voter registration database from the state of Maryland, one of 30 lawsuits the department has brought against states. There was a hearing on June 10th. Yeah, June 10th, here in the federal district court in Baltimore, in front of Judge Gallagher. The department argued on behalf of their position, was joined by amicus on their side. I had the honor of arguing on behalf of Administrator Demarinis. I was joined by 2 co-defendants counsels for different defendants in the case. I'm happy to say that 12 days later, on June 22nd, the court granted our motions to dismiss. We prevailed. The Department of Justice's lawsuit was dismissed. At this point, the department has not yet appealed the case. In other cases like this is now the 9th case to be decided, all of them against the Department of Justice. In 8 of the prior cases, the department has appealed. I will add, however, that one of the earlier cases from the Western District of Michigan, the Department of Justice appealed to the 6th Circuit, the United States Court of Appeals for the 6th Circuit. Yesterday, the 6th Circuit ruled in favor of Michigan, and in a published opinion, affirmed the Western District of Michigan that the Department of Justice is not entitled under Title III of the Civil Rights Act of 1960 to demand unredacted voter registration databases. So that's our first appellate court to support our position. Number 5 on the list, Republican National Committee et al. V. Demarinis, no updates. That is just awaiting a decision from the federal district court. We have finished briefing the motion. Both parties have finished briefing the motions to dismiss. Number 7, in the matter of Seth Wilson, this was a state court lawsuit seeking judicial review of certification of the ballot. It came for a hearing on June 4th on an expedited schedule. And on June 4th, from the bench, the court ruled in the State Board of Elections' favor and granted the motion to dismiss. And that case is at final judgment. There was no appeal taken and is now over. There is an 8th case, which started after I authored this report to you. It is Taylor et al. versus Maryland State Board of Elections. On election day, the State Board was served with a complaint by 9 candidates, 1 voter, and an advocacy group called Maryland Election Integrity, trading as Secure the Vote Maryland. The complaint seeks declaratory and injunctive relief that the board's handling of mail-in ballots during this election violated provisions of the election law article, and seeking injunctive relief having to do with transparency and accounting for mail-in ballots and permitting more voting opportunities after the canvass. Along with the complaint, the plaintiffs filed a request for a temporary restraining order. That request was denied by order. I think that was filed last night or yesterday afternoon. We received it this morning. And so there is no temporary restraining order in force, and the state board is free to continue, and the local boards are free to continue canvassing mail-in ballots as they have been, as guided by this board's policy adopted at its June 9th meeting. We will see what comes next in the case. The temporary restraining order is a kind of midway point, not a midway point, but it is a point along the life of the case. What will happen next, we'll see.
Thank you very, very much, Dan. Are there any salutations, solicitations, questions, inquiries for the heroic and tremendous effort exhibited by our Assistant Attorney General, Dan Corbin? No
Okay.
salutations? No
Yeah.
hoorah? No, you go? No, you are the man, Dan? Okay. Yes. Member Jackson Stanley.
Let's say you are the man, Dan.
Thank you very
I
much.
read
Appreciate it.
all of the information that you presented to us. Took me like 2-3 hours, and it took you 10 minutes to say, never mind, it's all resolved. So congratulations. I know you put in lots of hours, and from my perspective, I'm not sure what the others will say. I appreciate the hard work that you have done to keep us informed and to prevail this way so far. And I look forward to whatever steps are next. I'm sure you'll take good care of the state of Maryland and everything that you do.
Much
Thank you, Mr.
appreciated.
Chair. Thank you, Mr. Chair.
Thank you, Member Jackson Stanley, Member Butler, and then the Vice Chair.
Yeah, and I got a question on the very first one, the
Sure.
California v. Trump. Can you just go through quickly what that was, what the lawsuit was and about?
Yeah, the president issued an executive order in March of, I believe it was March of 2025, directing states to or requiring states to require documentary proof of citizenship in voter registration activities. That was the primary thrust of the executive order. There were other portions to it and other ways to leverage that demand, including funding resources and directions to the Department of Justice to investigate whether states are complying. There was also a directive for states to stop counting mail-in ballots if the ballot was received after Election Day. And essentially, the lawsuit was pushing back against that executive order to say that the President of the United States does not have the authority under the US Constitution to direct states how to conduct elections, that Article 1, Section 4 of the Constitution grants that right to state legislatures unless preempted by Congress. And so we're looking at what the state legislature has told us, and if Congress has told us anything, but a president using an executive order is not permitted to do that kind of directive. The court granted some of this case. We sought a preliminary injunction in 2025 and got it. And so the executive order was enjoined or has been enjoined for almost a year now. What happened in the case recently is that we won conclusively, that the court has decided with finality the state's challenge is correct, that the president does not have this authority, and therefore the portions of the executive order that the president doesn't have authority to execute are not enforceable in the states that have sued.
Okay, because that's, whenever we talk about this, when we talk about requiring documentary proof of citizenship in order to register to vote, and I don't see how that's a win, for people, or a success when we're not getting documentation to make sure people are citizens. But there is more to it, and that's what I wanted you to do. There's a whole lot of other portions of this bill why you feel that is a success, because we've had an issue of having an out-of-state person and a not a registered, not a citizen, and whatever on our rolls, and so I'm checking the rolls is an important thing for me. So I just want to.
And that's and the important thing that I think you've pointed out is there's a bill, right? Congress is considering a bill called the SAVE Act, and Congress's consideration of that bill is one thing. It has not passed into law. It has not passed the United States Senate, and that the president tried to do this unilaterally without Congress, which is what we have prevailed in this lawsuit and fighting against.
Right. Thank you. Okay. Thanks.
Thank you. Thank you, Dan, and thank you, Member Butler. Member Shelley, Vice Chair.
Thank you, Chair. Yeah, Dan, since I've been on the board, I and others, we've been sued with our individual names and collectively as the State Board of Elections. So you're our lawyer. And as a lawyer myself, I just want to say that I think you do an excellent job. I've read some of your pleadings and listened to your arguments. So kudos to your legal skills. I think you're an excellent lawyer.
Thank you.
I think I've asked you this before, but people want to know. I get a lot of daily. I get questions every day from people. I don't know if you can answer this, and if you think it's an inappropriate question, just tell me. These lawsuits are coming in with national issues, political. They're all over the news, and we are sued. The five of us are sued in many of these cases as defendants, and you're our lawyer. So my question is, when a case comes in of national import, like what mail-in ballots can be counted, can early voting be eradicated? These are major national issues. In Maryland, when a case comes in, if you can tell me, and if I'm wrong, let me know, who is the decision maker in terms of what you put in your pleadings and arguments? Is it you? Is it you and any members of our board, or is it the Attorney General? Is it the governor? In other words, who is the final decision maker about what we, the board and the state of Maryland, says in our response to these lawsuits? Who calls the shots?
Sure, I can answer as best as I can, obviously, in open session, and in sort of the role of the Attorney General generally in relation to state agencies, right? Because our relationship is not unique. The Office of the Attorney General is the largest law firm in the state, staffing every state agency in the state with attorneys. So I think it's important to note first that the first two lawsuits, California v. Trump, the first lawsuit and the second lawsuit on the list, were affirmative litigation, that nobody sued the state board in that lawsuit, that Maryland as a state joined as a plaintiff in a lawsuit. And so that decision had nothing to do with the state board. It doesn't name any of the 5 members of the state board. The state board was not a party. That's on my report because it so obviously relates to election policy and how the board is able to do its job. But they were not lawsuits that involved the state board. And so the state board doesn't have any authority or power to direct involvement with those specific lawsuits. Generally, affirmative litigation on behalf of the state is handled by the Attorney General, and the Attorney General's office decides when and how to engage in affirmative litigation. When the state board is sued as a defendant, when you, Vice Chair Shalek, or any of your colleagues on the state board are sued, you're generally sued as state officers. Now, this is a difference in federal court and state court, but when you're sued as state officers, what's happening is you're being sued as the state, as vestiges or authorities of the state. The state is being sued. And when the subject of that lawsuit is a state policy, a state law, a state practice, something the state does, the Office of the Attorney General is responsible with defending the laws and the policies of the state, with defending state officers in their conduct of state duties and state laws, and with the laws themselves. So when we get a lawsuit that challenges a state law, Comar regulation, an election law article statute, or a policy of the board in conducting an election, the Office of the Attorney General is obliged to defend the state's policy or law. The type of lawsuit, which we thankfully haven't had yet, but that sues you in your individual capacity for something that does damage to someone else. And you can think of a slip and fall case, or if you leave a pile of logs or tinder outside the office and it falls down on someone, that is a situation in which the Attorney General's office, would likely or could defend you. And we can get into that process. But that is closer to the situation where the decision to defend and how to defend would more closely involve a member of the state board or the state board itself. Obviously, there are different decisions during the life of a lawsuit that a client makes and the state board can make. And we've had those before, especially in potential settlement negotiations. But ultimately, defending the state, its policies, and its laws falls on the Attorney General's office.
Thank you, Dan. Thank you.
Thank you. Anything else? All right. Thank you very much, Mr. Corbin. All right. Now moving on in our agenda, Title 13 waiver requests. And I'll turn that over to Jared, the state administrator, and
Thank
his
you.
staff to present those waivers. Have all the members reviewed those waiver requests? Have you received them and reviewed them? Thank you. Just wanted to make sure.
So, yeah, so before I present them, I forgot one thing to present in the admin report, and that was and Member Butler knows quite well. We used to get complaints about our drop boxes being locked because the lock was on the outside, and since that last election, we had made modifications to the drop box to remove that lock, and I can happily report that we did not receive any phone calls about the drop boxes being locked this time. So we listen to what the public has to say, and we make the modifications to enhance their voting experience. So I thought that was I just wanted to say kudos to that entire team again for making those modifications, because it ended a lot of angst and just the people thought that in confusion that they thought a Dropbox was locked because they saw a lock on the outside of it with the flap. So that simple modification ended all those problems. But now on to Title 13. In front of you is our memo here that we are submitting, for 37 requests for reduction or waiving of the late fees. I'm happy to answer any individual questions. And then we have 4 denials that the board doesn't need to take any action on. They're just there for basically for your edification. And, but overall, with that, I present it for approval.
Thank you. Member Shalik, Vice Chair.
Just very briefly, who are these filers? Which group of filers are in this category?
This is the campaigns, the candidates, political action committees, Title 13 filers are the political committees.
And they have been fined or not fined because they have not filed on time?
They've
that-
been fined because they have not been filed on time, and then they have,
Okay.
and this is the waiver process in which, because we can't extend the deadline that is set in stone. But so if they, have just cause for their reason, then, we would present or grant it. Or, we have sent stuff over to the state prosecutor's office, and the state prosecutor has refused or doesn't want to prosecute due to other extenuating circumstances. So this is the waiver process then to remove those fees and sometimes help even close these committees.
Thanks, Chairman.
All right, thank you. There's no other questions. Chair's open to a motion to accept the state administrator's. Okay, Member Butler, is that a question?
Jared, the new system that we put in,
Mhm.
I know in the very beginning, we had lots and lots and lots of them. Are people finding this system easier as they've worked their way through it? Are we having less and less complaints because you get the complaints at your end?
Yes, yeah, I think as you saw just on the last report that was filed, we had a 91% compliance. So, I think it was, just the initial one there, and now you saw a higher level of compliance. We have done, worked with all the treasurers and the committees. We always have open sessions, and we will continue to do so throughout the general election as well. So there's 2 pre-general reports that we'll have, making sure that, we have, support from our vendor, as well as open lines for people to call in just for those questions. They don't have to get routed through the main line and everything else. So that they, so yeah, we've made sure that we wanted to, get compliance.
It seemed like it was getting better, but because we're like a month behind, we can't always tell.
Yeah,
Okay.
exactly. Yeah, right. And all you see are the complaints.
I'm aware of that.
Right, exactly, right? Like, there's over 1,400 like active, 1,600 active accounts here. So, when you put the, 37 is a very small number of like people that, and some of them had like other issues, as you can see, hospital or anything else that, would just be there.
All right, are there any further questions? Concerns? All right, hearing none, the chair is open for a motion to accept the state administrator's recommendations. Title 13 waiver. So moved by Member Butler. Is there a second?
Second.
Please seconded by Member Jackson Stanley. All those in favor, please indicate by raising your hand. So moved unanimously. Thank you. All right, now Title 14 waiver request.
Sure. So, this is, we have two groups here, just, but basically, there's, one that was declined to be prosecuted, and then the other one are 16 entities that either employed a lobbyist or had government contracts and are asking for waivers. We had reviewed their requests and made recommendations to either reduce or grant the waiver on those processes there to also help facilitate close. And to answer Vice Chair's question before he asks, this is so the Title 14 is as is known is for businesses that have government contracts of $200,000 or more, and or there's another part of the in the ethics law with they have employed a lobbyist with compensation of $500 or more. And then they have to report their contributions of $500 or more in the aggregate on the biannual report. So they're due at the end of May and in November. This one, because May 31st was I think Sunday or a holiday, it was a Sunday that it was then due on June 1st, and then the next report is due November 30th. So, but we work closely with the state prosecutor's office and also the State Ethics Commission because they're also the enforcement agency on this as well. And with that, I submit
Quick question.
request.
Quick question.
Yes, Vice Chair. Member
Thanks,
Shaw?
Chair. Jared, why is this category of entities filing with the Board of Elections? And from what your description is, these are not participants in the election process. Am I missing something?
I forgot. I couldn't read all your mind there. I thought I answered all your questions beforehand there. But so I mean, let me just say this: the Title 14 portion about government contracts that has been in law since 1974. It was Maryland's try to attempt for pay to play with it, so that was always there. And the other one about employing a lobbyist was, I believe, enacted in 2000. So that's been around for 26 years. Uh, you know, uh, you you can contact the General Assembly back in the, why it comes to the state board. I think it's just because they want to have it sort of for campaign contributions, and it's it, that's why it comes back. But it's interesting because the enforcement agencies are still the state prosecutor, and the other one is state ethics. So, but yeah.
All right. Member Shaw?
No.
Is that you?
I'm
Okay,
fine.
okay. All right, with that, the chair is open for a motion to accept the recommendations from the state administrator to waive Title 14
So
request. So moved by Vice Chair. Is there a second? Properly seconded by Member Butler. All those in favor, please indicate by raising your hand. We have unanimous consent. So moved. Thank you very much.
Yep.
Now, with that, we are on to old business. Member Butler.
Okay, old business is, I've been bringing this up for months and months and months and months and months, and we're gonna have to deal with it because as I watch the legislation change, we still have a problem with our list. And we have a problem with our list of voters. The list, especially now that the post office is not gonna mail stuff unless we have good lists, but every time we have an election, I have voters that call me up, I got 4 ballots, I got 3 ballots, I got 2 ballots, I didn't get any ballots. Our list is just not in good shape. And part of the problem lies with the legislators. They have the way they have written up how we can take people, how we get people onto the inactive and then off of the list. They've kind of hamstrung us. And I think we need to do our little committee that I keep asking about. And, you know, I think that as we could talk as a board to figure out, you know, who else should be on this committee to help us deal with this. But we're going to have to do this because we put people on the inactive list, and then if we mail out this postcard and then they don't mail the postcard back, we stick them back on the active list again. They didn't mail it back because they moved away 4 years ago and the new person threw it in the trash. We're just not cleaning our list. And conservatively, 10% of this list is bad. That's 400,000 people. That's the voters are paying to mail these ballots out to people and to mail stuff to all these people. And you know, when we continue to get issues. You know, we've had issues with people that are not citizens on this. We've had issues with people that are not living in the state on this. We have to do better than we are. You know, Eric has now moved up to 27 states, however, or with DC, whatever. That's still the other half of the country is not on that. We've got to work together to find better ways, like the NVRA, I think, has ways that we can work with them. Yeah, I think it was the NVRA that used to work with the post office, and the post office was very good. And they used to have all these little numbers that they would use and say, you know, what happened with this voter and that voter. And I think that when we used to work with them, I think we did better with the list. So we have hit the national news too many times this year, and some of these issues are this list. And we just have to stop. We've got to find a way to vet besides just saying, oh, here, yes, I'm a citizen. That's not good enough. It's not good enough for our list. It's not good enough for our citizens. And it's not good enough to disenfranchise a citizen because somebody else is voting that shouldn't be. So there's so many issues here that, I started this back before we had a lot of this mess either, because it's been a problem for years before when I was on a county board and for us, a committee of some kind. It doesn't even have to be paid. There's enough people out there that are willing to volunteer, that work within the system, help make this, and then bring the suggestions to the legislators so that we are not constantly putting people on this list and then taking them back off of the list without ever finding out whatever happened with these people. We need to have the voters deserve better. They do. And the list is not good. We have counties that have over 100% of the voting age citizens on the list. It's statistically impossible, not just statistically improbable, it's impossible. And we have more than one precinct in Montgomery County, I know for a fact, that has, you know, a bunch of these that are over 100%. 100% of everybody, they just don't go and register. 100% of everyone doesn't do anything. They're human beings. They're allowed to do whatever they want. These numbers are just not good. So I've danced around this numerous times, but I'm asking this committee or this board to set up a committee of some kind. We can talk about how to do it, but I'm asking in a public meeting because I have been harassed and harangued so long for this. We need to get it done. And I have seen it for a decade now, and it needs to be fixed. So I think that the taxpayers deserve better instead of just sending stuff out. And it will help with the chain of custody of ballots. It just will help with everything. And especially now that we're going to have a list that is sent for all the mail-in votes, you know, to the post office and stuff. We've got to have our ducks in a row. We don't. And so I would ask this committee for ask this board to set up our committee. And like I said, we can talk about how to do it, but it needs to be set up. Thank you very much.
Thank you. Member Shallot. Vice Chair.
Thank you, Chair. Yeah, I strongly support what Diane says. You know, I was president in Montgomery County for 6 years, and it was constant criticism from the public and inquiry that our voting rolls were not accurate. I mean, we were accused year after year of having more registered voters than people who live, residents in Montgomery County. And we were sued and attacked, and it continues. The issue of our voter roll doesn't go away. So I support Diane's recommendations that our board set up. Again, I use the word independent. I like that word. Group of citizens, bipartisan, certainly with participation from representatives of our board, I mean, of staff, not to exclude any entity, set up a group of people to finally go through our voter rolls, and as long as it takes, clean it up. I think that's an excellent way to go, and it also buffers us from criticism that we don't do anything. You know, we have 4.3 million voters, and it's time to clean it up. And I don't see any harm to it. I don't see any criticism attached to doing this. But you know, Jared's staff is very limited. You know, it's a limited staff here in off season, and we just don't have the personnel to do it. It's a huge task, and I think it's a well-founded recommendation by Diane to set this up and let people go through this and clean it up. So I thank you, Diane, for bringing this up. I think it's very important. Thank you, Mr. Chair.
Thank you. And just for point of clarification, based on something you just said, Vice Chair, with regards to cleaning something up, is it the voter rolls or the legislation that establishes the rules around the voter rolls? So I heard Diane talking about the legislative component, and I hear you talking about the list itself. So it seems that the committee would either be looking at the legislative fix, or the committee would be actively engaged in cleaning up the voter rolls. It's somewhat unclear. So if we could, I understand the idea, and Diane, we've talked about this. You brought it forward. It is acknowledged, but presenting so that we have understanding by all members as to what this committee would look like, what they would be tasked with. There's nothing wrong with drafting that up, sharing it with each member individually so that we can work forward with getting it to the state administrator with comprehensive input as to how the committee will be set up, if it will be in fact set up, and what they will be tasked with doing. It cannot be much ambiguity with regards to their task and their direction. And so we need to, and from what I'm hearing, there is, and I may be mishearing, that's fine, but let's draft it, the proposal to establish the committee, share it with the members for member input. They may not agree, and we have to be fine with that, and that's that individual. But that is work. Well, we don't have to be fine with that. We can recognize that. But we should work collectively towards that end, especially if we're looking to make it, as the Vice Chair indicated, independent, so that the trust is there to a certain degree as far as we can make it ironclad. But and also due to time and who would appoint, would it be a gubernatorial appointment to the committee, or would it be a bicameral office appointment via the Senate President and the Speaker of the House? I think we need to be clear and include them if their input, if that is something they would be inclined to entertain and or support, especially if there is a legislative component to it. So doing our due diligence, I greatly appreciate you bringing this back up and keeping it keeping it in front of us. But I do think we need to get our collective understanding and will together to address this issue.
Thank you, and I'll call Senator Kagan too and have her,
Mr. Chair,
if she helps.
Mr. Chair,
Yes, Member Jackson Stanley, thank you.
thank you. I'm going to chime in on purpose this time. The minutes reflect that I chime in often, I thought. I don't know what that means, but that's okay. I do support the idea of cleaning up the voter rolls. I do. I support that. But as our chairperson exquisitely described, it's something that we have to pull back and ask the legislators to decide how we want to do this massive job. Because as I heard Member Butler speak, the legislators did this to us. It's our responsibility to get the voter rolls cleaned up, but they're the ones that created this dilemma for us. So compiling or recommending a committee would definitely have to go through the legislators, ? If I understood our chairperson clearly, and I may be wrong, I'm wrong a lot of times, so correct me if I'm wrong. It's above our pay grade, if I may use something businesslike, to develop a committee that the legislators have indeed set us up to handle. The committee would have to be bipartisan, and speaking as the only person from the Eastern Shore of Maryland, also a representation of the entire state of Maryland. No disrespect to Montgomery County and all the other metros, but we on the shore also have some say, and we're pretty attuned to what's going on in the state of Maryland. So however it pans out, please make sure that the entire state, not just the metros, have a part in this conversation. I support an idea that time has come. If it's been years in the making, it sounds like it should have been thought out before, we had to deal with it head on. Let's get it done. I believe in getting things done, but get it done the first time the right way and include others other than we five. Thank you.
Thank you very much, Member Jackson Stanley. Thank you, Member Butler, and thank you so very much, Vice Chair, as well, for your input. I'm sorry, Member Bryant. I saw your hand a little late. I apologize. Member Bryant.
Thank you, Mr. Chairman. Since everybody has spoken to this, and as Member Jackson Stanley said, you with equal eloquence as Ms. Butler and Mr. Shallett. So I appreciate your ability to manage this and to see all aspects of it. And I've absolutely learned from the dialogue. My simple observation as one of us, and we all bring ourselves to the table. My simple observation as one of us is I would hate to put this item in front of the first things first items, the agency known as the Board of Elections and the state of Maryland known as the state of Maryland, the obligation it has to count all the votes from a primary gubernatorial election and then to get ready for and execute a November general election. So said differently and hopefully more concisely and more directly, I appreciate the will of the body, and obviously the will of the body is the will of the body, and your leadership is, paramount, Mr. Chairman. But I don't want to get too far ahead of an existing canvas and a duty to do a November 2026 gubernatorial election, and staff and everybody else at the local level and the state level have limited capacities to do but so many things. That's my only perspective. If I were to add to that same perspective, in terms of timing and priority, I know it's a conversation that's been happening for some time, but as the vice chair may agree and council may agree, if there is an issue with the voter rolls, and I don't know that, and if there are issues with the law, they can't be addressed until January. But if it's been the case for 1 year, 2 years, 15 years, or 25 years, I don't know that we we break anything by taking our time and making sure we prioritize the existing canvas and the November general election. That's
Thank
my
you.
only thought.
Thank you very much, Member Bryant, but I don't believe we put a time frame on this. But I do appreciate that and recognizing our priorities. And I did not, and I would not limit the members from acting, continue to act proactively and getting in establishing um, resolve for their concerns. So I'm not pushing anything on the back burner due to our current priorities, but I would like for us to move forward with working with the members, Member Butler, to address this concern effectively. I have asked Member Butler to give us a clear direction with regards to um, point of attack to address the voter rolls, whether it's legislative or whether it is direct um, uh, oversight of the committee to be recommended to have direct oversight and review of the voter rolls, which I don't think we would have the wherewithal or the security clearances to conduct. But I wait for that direction from Member Butler to give us a clear outline and direction of what that committee's role and responsibilities would be. State Administrator.
Yes, thank you. I just want to, before, if anybody's watching or listening to this here, I just want to make sure that they come away with this idea that, one, State Board of Election follows federal and state laws in compliance with the voter rolls. The voter rolls our procedures are available. We're transparent about those. They're available on our website as to what the process are, and that we follow all the processes, and that the general public and voters can feel confident in our administration of this. We have, Maryland has made a policy determination as to what they want to create, and they didn't want to have any barriers to individuals registering to vote. And these are legislative matters that are not, that should be debated in front of the General Assembly or in front of the US Congress. This is nothing that is, inside the purview of the State Board of Elections. And I just want to make sure that voters understand that, yes, people have their concerns and that there are issues out there that they, but we do our job, and that we follow the law and we follow it correctly. And that, Maryland has made a policy determination for this. And it is vital that people come away with the idea that, our roles are up to date and accurate. That is my responsibility under the law to ensure its accuracy. And that is what I do. And I take that very seriously, because that is the first way into the process of your constitutional right to vote. So it's vital that people understand this and that we follow all those procedures, and they're outlined out on our website so everyone can understand that. There is no issues that address the procedures that are in place or the application of those procedures. And I want to make sure that people understand that. Thank you.
Thank you very much, State Administrator. Member Butler and then Member Bryant.
Jared, I understand what you're saying, and we're following these procedures the way that it's set up. It is not working. We know it's not working. I'm not trying to upset the public or anything else. The public continually comes to us and says, I got this, I got that, I got, I took my own daughter took herself off the list, moved away, 7 years later, came back, was still on the list, and I checked on it. This was a decade ago. This list has some issues, and we have to do our due diligence, because when we do our due diligence, then the voters trust us more. And if we have a system that is dumping stuff into one pile and then putting it back into another pile because the legislation hasn't been done right, or whatever it is that's doing so, we need to clean it, and we need to fix it, and we need to fix the issues where they are, which is why, Michael's right. We need to figure out who needs to be on this and who needs to be, how far we go with this, where do we take it to the legislation later? But there are issues there, and the legislators know this too. There are legislators that are well aware of this. So to do our due diligence for the voters, we have to have a clean list, and our list is not clean. And so we need to, even just for the taxpayers, for us not spending their money sending out ballots or sending out information to people that moved away 10 years ago, that saves the taxpayer money because we pay to, for all this stuff. So saving the taxpayer money is never an issue. The voters would prefer that. But we need to fix our issues. It's not a personal offense against you or the way that it has been written, but we've changed so many laws so quickly, especially with mail-in ballots, and we did a lot of it under emergency legislation, and then we had to go back and review and go look at the emergency legislation 3 or 4 different times, and then we go back to the next election, we found another problem with it. It needs to be looked at, and we need to fix this list. So that's
Thank
okay.
you. Thank you, Member Butler. I appreciate that. Member Bryant, you had your hand up. Are you still? Okay, go ahead. You're on mute.
Okay. Yeah, yes, sir. I appreciate being acknowledged, and I appreciate, as always, Member Butler. But I raise my hand in this instance to acknowledge and thank Mr. Demarinis for reminding us that the law is followed. And as we stand, the American people, but more importantly, the people we have an oath to, the people of Maryland, can stand ready and confident in the voting system, not just as it relates to the ballots that they cast on Tuesday or during early voting or in the mail-in sense, but as it relates to the voter rolls. So to bring us back to center on that is something that I really appreciate, Jared. And for anybody who's listening, we may have sort of skipped one half a step and raised the notion that some of these considerations that will be on the memo or the cheat sheet or the thinking process that Member Butler submits to Chair Summers could relate to what the United States Congress is prepared to debate, or the President of the United States wants them to debate. Something as simple as a policy of license or no license, passport or no passport, citizenship or no citizenship. But in the moment, as Member Butler said, legislation has been passed. As Mr. Demarinis said, there are laws on the books. There's a General Assembly and actions signed by various governors over any number of years that have set the landscape for where we are. And those actions and those laws are followed to the letter and to the T. Indeed, some of them are federal laws. If we may bring in the Help America Vote Act or Voting Rights Act or any other collateral assignments. So thank you, Mr. Demarinis, for doing that, because one of the things that I think the entirety of we all have to do is to be clear that there should be the utmost confidence in the voting system and the voting apparatus. And to the degree that we're talking about policy matters of the legislature or interpretations that any individual board member might have to make those edicts better or worse, they're just that, but not necessarily a fix or unbroken or right or wrong or don't trust the system as we have it. Thank you, Mr. Chairman.
Thank you. Yes. Now, Member Butler, do you have any additional recommendations under old business? Okay. Thank you very much. Understanding that you will get me that information, also sharing that with other members one-on-one, not collectively, to avoid any ethics issues or violations of the Open Meetings Act. All right. Thank you so very much. I appreciate your patience. Thank you, State Administrator, for your input and assurances. I don't believe that any of this is an indictment against your efforts, nor the will of the state. It is purely for inquiry purposes. All right, and making recommendations. So thank you. With that, we're moving on to new business. And new business, I believe, Member Butler, you had an issue to add to the agenda.
Yes, thank you. New business, I think we need to look, Jared, at a policy for canvassing. Between the new Open Meetings Act that Senator Kagan put through and the legislative passed, we're having a lot of complaints about the Open Meetings Act and canvases and being able to observe the canvases and observers. And a lot of times, if the state can give some kind of guidance here along the line, I think it's helpful. I think that, the people, the counties that do come to the meetings and listen, it tends to help. Because I've got, all kinds of calls and complaints today for the first canvases and the other canvases. And we have changed how we canvass. Once we changed to so many of the mail-in ballots, we started doing canvassing even beforehand. But people are aware of a canvas now. They're more aware of it, and they're actually observing it now. So I think helping the directors to work with the citizens who want to observe, as well as protecting, the judges that need to, that we're hiring and, to help do the canvases. I think sometimes people, they're used to doing things one way, and because I know in Howard County, I apologize for that. In Howard County, we started out doing ours in one room, and then, we had to move to a bigger room, and then we had to move to 3 rooms, because we're inviting the public and we're doing more and more canvases. And we had to, keep changing what we were doing. And fortunately, the director there was good about doing that and setting up an area so that people could actually observe. And so that's important. So maybe we could talk about or think about how we could set up a policy for canvassing that works well for the directors as well as the observers, and maybe, moving into bigger spaces and stuff, a little bit bigger space so that the canvassers are allowed, or the observers are allowed to actually see what's going on. So it's an idea that I thought I would bring to you because of all the phone calls that I get all the time. So, okay.
All right, thank you. Member, State Administrator, did you have a comment?
I think Vice Chair.
Okay. Member Shallot, Vice Chair.
Thank you, Chair. Yeah, again, Diane, thank you for your concern about this. Yeah, in the last day and a half, I've received a number of inquiries and concerns from Frederick County. Apparently, there's an issue with where the observers can participate and walk around the canvas, or do they have to be sequestered to an area where they can't have closer access to the canvassers? So Jared, I don't know if this is the right time to ask, but I know the definition of reasonable distance is the key phrase from where observers can participate in their observations of the canvas. What is your interpretation, the board's policy in terms of what is reasonable distance for a observer to be at? Apparently, there's an issue in Frederick between the staff and people that want to observe as to what and where they can go. Do we have a definition or something that's helpful to that situation?
It is in Comar. I believe it's 3308-0302 about reasonable distance. And, so at a reasonable distance, but they're not allowed to touch them. And the idea about going around or wandering during the canvass is definitely prohibited. Like, we're not going to have, people that, they cannot touch the ballots. They can't, attempt to touch the ballots. So, they're not, election judges swore an oath. They've been trained, and the canvass is under public observation. Remember, the canvass is also conducted by bipartisan teams, as well as the board of canvassers itself is comprised of bipartisan members. So the political parties themselves have their representatives already as one, as a member of the decision-making board, as well as you and Member Butler know. So, yes, the candidates have the right and the public have the right to observe at a reasonable distance. Each, and as both of you are well aware, each local board has its own issues with, areas, so that they have the right to see the process, and if they want to see an application, I think Montgomery puts it up on a screen so that people can see it. Like, other places probably show it, but it is open and transparent, and it gets difficult to actually legislate or to create regulations in a way that allows for every polling or every canvassing area to be. So that's why I think the regulations itself state reasonable distance, and we can work with, and I understand the concerns there with the locals there, but the canvassing boards themselves are made up of bipartisan teams, so that if they can also talk with their election director and say, well, then maybe we can move them in a little bit closer themselves. So this is best handled, I think, at the local level, but we can look into it and develop a policy. But it is current regulations, so it would have to go through that process as well.
Is it fair to say that the election director is the person that defines reasonable distance in terms of the observation of the canvas? It's their call.
I would say that, but the local board of canvassers can, has the ability to adjust it. They're there.
Okay. The local issue, in your opinion.
Because they're the canvassing, they're the bodies that are doing the canvassing. We set the policy we set the guidelines, so that it's universal across the board, but a reasonable distance for observation is the current COMAR standard, and we can take a look at it and see what other issues come up. But
Thank you, Chair.
and the board attorneys are there as well. So remember that.
All right, thank you. Anything further on those? Any other questions, concerns regarding this matter? Okay, hearing none. Thank you very much for that input and that exchange. We have two speakers today. I don't have on the agenda who will be the first.
Okay. The first one is Ms. Porter. Shion?
That's Susan.
So I think we only see, there's only one that is currently on. So we just can go with the one speaker. The other one.
Okay, is that Susan?
Yes.
Okay. Thank you.
The other one I don't see on right now. So yep.
Okay. So it's Susan. Susan has the floor at this time.
Okay, thank you, Chair. My camera doesn't seem to be showing. That's
Okay.
fine.
It is.
Okay.
We can hear you.
Okay,
Hearing
thank you
you.
so much.
All right. Thank you.
Sorry, it took a second to log to open up. Thank you, Chair Summers and members of the board. I am the Senior Advisor for Election Security at Free Speech for People. As you may recall, I'm here speaking today on behalf of my organization as well as Common Cause Maryland and Save Our Votes Maryland, which I would just like to clarify is not the organization affiliated with a lawsuit that was mentioned
Thank
earlier.
you, Susan, for that. Also, just to remind you, you have 3 minutes, and
Yeah.
if you do not conclude, you will be cut off. I apologize. in
Okay.
advance. If that happens. Thank
Can
you.
we start now then? Because I had started my
Yes.
call. We again are urging the board to take steps to pause the proposed voting system procurement, which is flawed because it is inconsistent with Maryland regulations and laws. At this especially volatile and litigious time in elections, we believe it is ill-advised to pursue this purchase, which appears inconsistent with Maryland laws. Maryland Election Statute 9-101C specifies that a voting system must be certified at the time of acquisition. The purchase contract the SBE has proposed includes two different versions of the voting system, one that is certified by the U.S. Election Assistance Commission to the old federal voting standards from 2005, and a second system that the vendor represents will be certified to 2021 standards before 2030. The second system or version of the system is not yet certified by the Federal Election Assistance Commission. Importantly, we wish to highlight for the board that according to the vendor ES&S's May 19th letter, ES&S admitted it hasn't even submitted its system suitable for Maryland to the EAC to begin testing to the 2021 standards, contrary to prior representations made to this board. We have no public information, marketing materials, or documentation about this system. All of this suggests it's still in development. The vendor has represented that this will merely be an upgrade to the system the SBE voted to certify in April, but that characterization is just incorrect, and more importantly, does not agree with Maryland state regulations. According to the Code of Maryland Regulations, COMAR 33.090302B2, each model or version of a voting system requires a separate application for certification, and per the statute cited before, must be certified before purchase. So including it in the purchase contract would be a run afoul of these requirements. According to the RFP and press reports, the proposed purchase will also include yet another third system to replace the electronic ballot marking delivery system that's currently being used. This will function as a remote ballot marking system and will also include a ballot remaking function. But this system has also not been certified by the EAC or the SBE. In sum, we urge the board to withdraw this proposed contract before it advances to ensure compliance with Maryland law and regulations, and for the SBE to pursue other options. Thank you, and I welcome your questions.
I got a question.
Thank you, Vice Chair.
Thank you, Susan, for your interest in this. Let me see if I can homogenize, that's a good word, put this together. Our board certified the new voting system a couple of meetings ago, and we were aware that we certified a system, let's say 1.0 system. And we were told, and we know, that there's going to be, over time, upgrades to a system 2.0. They're going to upgrade equipment, things like that. Why, and I think, correct me if I'm wrong, Jared, this matter is supposed to go to the Board of Public Works, the governor and the controller and the treasurer, like next week. Why is it that you say we should put a halt on this and not give it to proceed to the Board of Public Works? Why do you say these aren't upgrades? I mean, this system is one of the most successful voting system in the country. And they're saying that here's our system and we're going to be upgrading certain materials and technology. Why isn't this just an upgrade? Why do you say that every time they do something, upgrade, put a new camera on a machine? Why is it that your position is every upgrade has to be certified as we go through this? Why isn't what?
I'm sorry, go ahead.
Sorry.
I'm sorry, Vice Chair. I didn't mean to cut you.
Why do you say we have to certify and not present it to the Board of Public Works until we certify everything they do to upgrade, that could be past our election? Why don't we rely on their expertise and professionalism, that they know voting systems and they're going to upgrade it to make it a better system?
Because the legal definition in both the Maryland COMAR requires that every version of the system and the and the U.S. Election Assistance Commission's definition is that any version that goes from one standard to the next is considered and defined as a completely new system. But you don't even have to get to the word system because the COMAR says every individual version requires its own individual application for certification. That was the COMAR that I specifically cited. So that's why it's not just an upgrade. It is a very significant change in the functionality of the software, and the way it's being applied, the way it's going to function. And that, by definition, makes it a new version. And according to the EAC, it is a new system because the software will be different. I'll also note that the letter that ES&S provided says that core hardware components will remain the same. And this is something that we had been concerned about because from my understanding of this, from having worked around the certification issue for a long time, that the hardware for 1.0 systems in some elements of it will not be compatible with 2.0. And we were really surprised that there was this assertion that it was going to be all the same hardware. But that letter seems to suggest that even ES&S is beginning to acknowledge there's going to be different hardware. So just the software itself is going to have different functionality because it is a different version of the software, because it will be certified to a different standard according to the EAC's definition, legal definitions, and according to the COMAR, that becomes a different version. And according to Maryland's statute, that requires a new certification.
Thank you very much, Susan. I appreciate that. For the sake of time, Vice Chair, I know you had a follow-up, but I have
I'm just wondering, what's the harm in
I
your
have
view, Sue?
one,
I'm sorry.
1 second.
Oh, I'm sorry.
I have Member Butler, and then before Member Butler goes, I will ask the State Administrator to speak to this prior to. I hope you don't mind, Member Butler.
No, she can speak first. Let her speak, and then we
Thank
can,
you.
then yeah,
Go ahead.
the questions answered.
Okay, go ahead, Jim.
Yeah.
Go ahead, Jim.
Thank
Finish
you,
up.
Chair. So Sue, what's the harm with us going forward with the Board of Public Works certifying it? And then while it's in place, if certifications are necessary, why can't they be done as we go along the process of developing this system? Why do you urge us to drop this system, not move forward, and look for somebody else?
Because
What's
I'm sorry.
what's the harm? I mean, what's the difference between what you're saying and my upgrades on my cell phone? I mean, my cell
So
phone, why do we have to keep certifying upgrades in a system that everybody upgrades this system?
So a cell phone upgrade is very different from a voting system upgrade because it has not been federally certified to a certain standard of performance. When voting system software is mission critical, it has to perform correctly, accurately, securely on election day. We can't take any chances. That's why it goes through a certification process. Certifying election system software is more akin to certifying FAA software in an airplane. We have to know that it's going to perform correctly. So you cannot make changes to FAA certified airplane software without it going through the process again. And it's the same thing with election system software. It cannot really be considered the same as a cell phone where you can receive an update. And I recently got an update on my cell phone and I suddenly couldn't work my FaceTime for a while until they fixed it. So we see things like that. There are bugs if you have an update. That's why it needs to go through the testing process again to make sure that the update doesn't change anything and ensures that it's still going to function correctly. And the reason that I'm saying it's better to pause this because the state law in Maryland says that at the time of acquisition, the system must be certified. But the way the contract is being structured, this quote unquote upgrade, which is the new system, which purports or is expected to be certified to the new standards, although again, it has not yet been demonstrated in Maryland. We haven't seen it. There's no marketing materials on it. It has not been submitted to the U.S. Election Assistance Commission for testing. That system is rolled into this contract and it is not certified. And the Maryland law says it needs to be the system has to be certified before it's purchased. So given the current climate and environment, I don't, we believe it is ill-advised to start trying to, look at uh, laws and statutes a little bit flexible way.
Thank you.
Thank you, Susan. Member Butler.
Susan, I remember you coming to the board after we had voted and we didn't get to hear your stuff beforehand. And I think that I would have asked more questions if I had heard beforehand. My concern here, this is a 5 system, the 1.0. And then my concern definitely is the core hardware not being compatible with the 2.0. Because that's a huge change. And I see why you're bringing this here, because you're saying that basically our law states that we have to have both pieces certified, but this 2.0 that they don't even have it ready for testing yet. That is what you're saying, correct?
Correct. Yes, that's right. Remember.
Okay. All right. That's it. That raises a lot of issues. And then this is a $100 million project we're dealing with here. I think there's some thoughts that we might want to take a look at here, but I thank you for bringing it, because I really wish you had brought this before so I could ask more questions before and we didn't certify, we approved the fact that it had gone through the testing at the 1.0, but 2005, the things have changed so much and will change so much, especially now with AI. I mean, it's going to change tremendously. And you said there are other 2.0 systems that have been out before.
Yes.
We were looking at it, but we didn't find, but there are some there out there.
Yes, actually, the second rate system that was considered in this procurement is 2.0.
It's already 2.0. It's already reached 2.0.
Yes.
Okay. Thank you very much for it. And I really appreciate the work and the research that you have done on this. Thank you.
Thank you for the question.
Thank you, Member Butler. Thank you, Susan. State Administrator, did you have something to speak on or question for Susan?
Thank you. I just want to, okay, I just want to say this, that, the procurement itself went through legal analysis and review. The certification process is what you performed, met all the legal standards as defined in the election law article. Again, the system that we are procuring meets all the requirements under the law for certification, and it is, for state certification, it met it. And as it moves forward through it, this is a contractual obligation for them to create a pathway to 2.0. The law, would still even, at no point has this system not be certified. Additionally, it's, the state law doesn't necessarily talk about VVSG 1.0 or 2.0 standards. It talks about being federally tested by an independent agency. We put that in the RFP because we wanted to, that's the easiest way to understand federal independent testing by an entity approved by the EAC or the FEC. So, we met all the legal obligations throughout this process. And again, this has been an open and transparent system. Remember, I had spoken to you numerous times beforehand, because when we had started this process over a year ago, the marketplace for 2.0 certified systems was zero at that time. And, during the course of the RFP, systems have now come online to 2.0 standards. This is a nationwide problem here that, is occurring because of the aging of all the equipment. Our current equipment is over 11 years old, and we want to be prepared for the 2028 election with the most up-to-date equipment, because it is a presidential election. So with that, we are working with the Board of Public Works, but the system itself has been EAC certified. It has been tested and certified at the state level, meeting all our requirements as well, and will meet the obligations as required by law for state procurement. So With that, thank you.
Thank you very much. Member Bryant.
Thank you, Mr. Chairman. I will be brief. I have a few thoughts. One thought is, if you ever see a board at the state level that wants to get involved with procurement matters, beware. And I say that sort of tongue in cheek and, with a little bit of jest. But I think in all my years of working with clients and governments, local, state, and federal, if you got a board too involved with a procurement, beware. So I think that this board is mindful of that and is beyond reproach in any particular way. With that said, there is some responsibility. Everybody on this board went to a clerk of a local court and swore an oath to perform some level of oversight. So there is some responsibility that has to be met as it relates to activities, including procurement, and to the degree that we're talking about $100 million, that should catch everybody's attention, and we should be aware of that. So there is a fine balance. I know we want to be mindful and we want to address our responsibilities as dutifully as possible, and that balance should err on the side of any board that wants to be too involved with a procurement. You should beware and watch out. With that said, my question is, what did we certify when we took the sole action that we have to date and sole involvement in this procurement when the board certified it? So the real question is, what did we certify in simple English? The context and deeper question is, did we certify EAC version 1.0? Did we certify EAC version 2.0? And if we certified EAC version 2.0, do we have that ability to certify 2.0 when EAC hasn't done it itself? So I hate to be at this road. I hate to be down this road, but if somebody gets to a governor, a comptroller, and a treasurer, and there hadn't been some level of discussion about it, I think a governor, a treasurer, and a comptroller, known as the Board of Public Works, would be well within its ruminants if they ruminated about the question of what the heck was the State Board of Election doing on this matter. So those are my questions.
Sure, and I'll be happy to answer that. The state board, we are procuring the EVS 6.5.0.0 voting system, and that has been certified by the EAC under the VVSG 1.0 standards. The RFP had outlined that the selected solution had to be compliant with the VVSG 2.0 standards by January 1st, 2030. So it is a contractual obligation for them to upgrade that. We are not at this particular time procuring a VVSG 2.0 voting system, but what we are acquiring has been certified at a federal level that meets the contractual obligations for it, and that any future work outlined would be represented as a contractual commitment. And that solution must complete federal and state certification for its deployment and operational use. So the acquisition would only occur upon delivery and acceptance at that point. But for 2028, what we are procuring is a federally certified, state certified voting system that works to be VVSG 2.0. But it is a certified system.
Well, to the degree that there was this requirement that the State Board of Elections, the 5-member entity, certified something, what did the state board certify?
You certified the hardware and software for EVS 6.5.0.0 6.5.0.0 voting system by ES&S.
Is that the 1.0 or 2.0?
That is the 1.0 system.
Had that been previously
and-
certified?
That has
Is
been
that-
certified by the Federal Election Assistance Commission for use.
No. What I mean is, had the State Board of Elections certified the 1.0 system in the past? More specifically, is that the same system that the State Board certified whenever the State Board procured
No, this
the
is a new
system that people used a day and a half ago, 2 days ago?
No, this is a new system. New equipment, new scanners, new ballot marking devices. It's, the speed of it is, they don't even make the ballot marking devices anymore that we currently use. So all this is new equipment, new
All
hardware.
right, and again, I really, from the perspective of any board that talks about procurement, watch that board. And I say that tongue in cheek, but on the different side of the same coin, there has to be some involvement. Otherwise, a governor, a comptroller, and a treasurer, I think rightfully says, what were those people doing before they got me figuring out what to do with $100 million contract? So what, if I'm correct, Jared, you're saying the procurement says 2.0 has to be
No.
certified before 2030,
Yes.
and we were within the confines of that procurement to certify 1.0, and these are subjective terms, as an interim measure. So when Susan and other people say 2.0 wasn't certified by EAC, they're a little premature because the procurement never contemplated EAC being certified before 2030. EAC 2.0 being certified before 2030 anyway. Is that right?
So we made it so that we had maximum flexibility in our contract, which I stated earlier, to get the most vendors to be able to bid on this contract, so that we wanted to get a good, healthy competition for state procurement, which is what we're required under state procurement laws to do. At the time when we were drafting the RFP, VVSG 2.0 standards were out by the EAC. However, no system was compliant at the time of drafting. We had to make a determination, at which point we had brought in the trade representative, which was mentioning the outline of when all the systems would be ready for VVSG 2.0 standards, or to meet that in the timeline there. They had given us a nice PowerPoint presentation, which is where we came up with the January 1st, 2030 deadline. But at this particular time, in order to, you get ready for the 2028 election, to have maximum number of competitive bids, we saw that, we had to go with VVSG 1.0 federal standards that are been certified. The equipment meets all the requirements under state law, because it doesn't talk about what standard it has to meet. It just has to meet a federal standard. And we put in the contract, making sure that it met the minimum of 1.0 at this particular time, and that it has to meet as a contractual obligation 2.0 standards. And the system that we are currently procuring and that we certified, that was the EVS 6.5.0.0 voting system, is, VVSG capable, but it is a contractual obligation for them to meet that January 1st, 2030 deadline.
Mr. Chair, Mr. Chairman.
So the entity itself that is procuring this understands that that is a contractual obligation, and failure to meet that contractual obligation, can result in other issues.
Mr. Chairman, point of order. And again, if you see a board that wants to talk about and be engaged in procurement matters, go run and get your lawyer, go running for the hills. So nobody wants to deal with this, but there is some obligation to, provide oversight as best possible, particularly given that it's been brought to our attention. But that's separate and apart from what I'm about to raise, Mr. Chairman. And this may be a function of council to consider. At what point does this concept of procurement matters, akin to personnel matters, akin to litigation matters, become a function of items more appropriate for closed session as opposed to this open session? Because again, one, any board that wants to get involved with procurement matters, beware of that board. And two, I know there are these notions and concepts that procurement matters are to be discussed in closed session, and I rue us to the degree that we go too far down the road on a procurement matter to run afoul of those advisements, if not those laws that say they should be addressed in closed session. Because I do have one or two more questions.
Well, I appreciate that, and I find value in your questions, and you're right. We will have a closed session, and most of our procurement matters are addressed in closed session for any issues associated with any RFP process or inquiry into selection process. So we do have that coming up for this meeting today. So I ask you, Member Bryant, if you don't mind, especially when citing counsel in your inquiry, if you could hold
Yes, I
until
yield. Thank you,
close.
Mr.
Thank you
Chairman.
very much. Member Butler.
Jared, okay, I think what I'm understanding, and I think what Member Bryant was asking, we certified that the testing had been done. Rules, I think is what we certified. I could be wrong, Jared.
But you certified use of the system for deployment and operational use in the state of Maryland.
Okay. So this system, the 2.0 becomes available.
Right now, I think
Yeah.
two.
I'm sorry, I didn't hear you.
Two.
We are going to retest it.
I can't quite hear you, Member
Yeah,
Butler.
exactly.
Some of your questions are going in and out because of internet reception. I think it's the internet reception.
Okay.
But we want to hear, I know I want to hear you. So just be mindful.
Okay, I'm asking Jared if we'll retest when the comes up to 2.0. The same kind of testing that we have done for the 1.0. And if they fail 0.0, we have an out of this contract. But what are we going to do if it doesn't meet what it's supposed to do at the 2.0 level?
So then at that point there, we would, I don't want to, get ahead, but that's a 2030 issue. But then they would not meet the contractual obligations. I would say
Okay.
we can, at that point there, there would be probably the cancellation of the contract for failure to meet provisions in the contract, and we would seek damages. We would go out for a new RFP immediately for a system, and that would be it would almost be akin to what occurred with our poll books, right? Which was the system failed to meet our standards for deployment and certification of its use, so we had to cancel that contract, rewrite the contract and send it out for bid and seek damages. That's why we put it as a contractual commitment.
I'm sorry, Member Butler, you're freezing up, and we cannot engage. We're not hearing what you're saying. You're freezing up terribly. I'm sorry. We
Answer.
we're really sorry. We definitely, as Member Brian said, we definitely want to hear what you have to say, but because this is a collective board, I don't know. Like, is she here? Okay.
Well,
All
if
right,
not, I think we can
Vice
probably
Chair.
address more of these issues during closed session if you want.
Yes, Vice Chair.
Thank you, Chair. So Jared, is it your position that we're going to the Board of Public Works next Wednesday to ask the governor and the comptroller and treasurer to move ahead with the $100 million purchase?
Yes.
Okay.
It is a state, we did all the certification, they met all the contractual the RFP. It was technically the best solution. And, we had our review process selected. We then, performed state certification that met all the requirements here. The board had certified the use of that equipment for deployment. And so, yes, all that, meeting all the contractual obligations, and, we're prepared for any and all questions at the Board of Public Works as well.
Mr. Chair, I noticed on my screen, I don't know if the other members, that Susan would like to respond to, I think,
Yes,
primarily.
I've seen that, and I have asked that she respond in writing to the SBE and to address the concern so that we all have it. Thank you. All right. With that, Diane, I wanted to make sure that you were heard by Jared based on his response to your inquiry. And she's gone again. Okay. We're having some technical difficulties. Although I will say, while she's coming back online, she can address those concerns in closed session. We are going to move into closed session today. We will not be coming back for open session. And this is in pursuit to the Open Meetings Act procedure for closed session. We will be under the statutory authority and general provisions
Mr. Chair,
are, yes,
Mr. Chair, based on the agenda, we need to set the next meeting date before closed session is called for.
true. I apologize, disclosure, because that was still after new business. We
Yes,
had
sir.
speakers. Apologies. Thank you very much, Member Jackson Stanley. Are there any, so now I have Diane Butler back. Just went to these questions, to the question on the agenda. Any disclosure of campaign contributions?
No, sir.
No.
Okay. Diane, if you can speak, we may not be able to see you, but we can hear you.
No,
Okay, thank you.
no comment.
All right, scheduling our next meeting.
Mr. Chair, you're breaking up
For
too.
July. All right, can you hear me now?
You're
Yes.
breaking up too a little bit.
All
Yeah.
right. Scheduling our next meeting, July. Can we look at our calendars? So 1, 2, 3, 4, 5. So there's five Thursdays. In July 20th or July 30th. Think we're shooting for the 23rd. I would like to.
By 23rd.
July 23rd.
Good.
Good.
All right, 2 o'clock. All right, thank you for that. Now.
2 o'clock, did you say, Mr. Chair? I'm sorry. July
What's that?
23rd at 2?
Yes.
Okay, thank you.
Does that work for you?
Yes.
Thank you.
Yes.
All right. We will, as addressed earlier, we will be moving into a closed session pursuant to the Opens Meetings Act procedures. Article under general provisions, Article Section 3-305B, to discuss the appointment, employment, and personnel matter. Also to consult with counsel to obtain legal advice and to consult with staff, consultants, and other individuals about pending or potential litigation, as well as to conduct a security briefing. With that being said, I have
Miss-
we will not be back into this. We will not be coming back following the closed session. Member Bryant.
Thank you, Mr. Chairman. I thought I heard you read the purpose of the closed session, but I don't remember you raising the notion of to discuss procurement matters.
No, it is in line with consult and obtain counsel, legal advice.
It would
closed
be.
session,
Yes, it would
the
be.
closed
It
session?
would be.
right, you requested of counsel pursuant to your procurement inquiry.
Yes, sir. So it
Address.
would be. It would be.
Right.
Thank you, Mr. Chairman.
Not a problem. With that being said, the chair is open for a motion to move into closed session and to adjourn from the open session. So moved. Is there a proper second?
Second.
Properly seconded by Member Jackson Stanley. Move on, the vice chair. All those in favor, please indicate by raising your hand. We have unanimous consent to adjourn the open session and move into the closed session. The closed session will start in approximately 4:25.
We have a new link for that, Chair?
It should be emailed to you in your inbox. Yes. It should be. If not, it will be there soon.